You may be seated. Good morning again. Before we get started with our second case, our panel has changed somewhat. To my right is Judge Harvey J., and to my left again is Judge John McGiver. This is the last case this morning. It's case number 2022-2429, Brandy Ainge versus Todd Goodwin. Is it Mr. Shack? Is that correct?
Yes, Your Honor.
You come on forward.
Thank you, Your Honor.
Absolutely. Did I get that name right? Is it Mr. Shack? Is that correct?
sorry?
The name, Mr. Shack? Is that
Schott.
correct? Is that, how many minutes would you like for rebuttal, sir?
5 minutes, Your Honor.
Okay, thank you. You may proceed when you're ready.
Thank you, Your Honor. Clay Schott and Bradley Lightbourne from the law office of Hogan & Hogan on behalf of the plaintiff, Brandy Ainge, in this case, the appellant. Your Honor, or Your Honors, excuse me, just briefly before I talk about my argument, the facts in this case have never been in dispute, and they're very simple. It's a bad accident. There's a broken femur. Client goes to the hospital. I wasn't there, so I guess I'll say Hogan & Hogan was retained. They sent a letter of representation a few days after the accident. That's on the 30th of May. Geico sends 3 responses out. They send a letter with some photos of the defendant's vehicle. They send a letter requesting a recorded statement, and then they send a second letter requesting a recorded statement and all specials. What they don't send is the policy limits disclosure in the case. They wait to send that, and when they do send it out, they send it by snail mail when all these other things came by fax. Then they send this check that says settlement of BI claim, those words. It doesn't say full and final, it doesn't say full satisfaction of the claim, and it doesn't say indemnification either. It just says $25,000 settlement of BI claim. Settlement of BI claim is in the smallest letters.
Well, I've got it here, and let's talk about it. It says in payment of bodily injury coverage, and then underneath that it says settlement of BI, bodily injury claims. How can you derive from that anything other than what it is?
Because it doesn't say it's policy limits, and it doesn't say it's full and final.
Well, is there a case where that has ever happened? Where a check like this with this language is divined to be something other than what it is?
In every case that you see that deals with this issue, there is a writing that says it's full and final. In the cases where there is no full and final language, the courts have ruled that it's not an agreement because it's not full and final, that it's not an agreement. And if I may,
I want to talk about the language, and you said it's a very simple case. It is a very simple case. The other thing, I personally, this judge, just one of 3, I don't understand why this was a jury issue.
Your Honor, the best proof of the fact that this was an issue of law is the fact that the lawyers were arguing case law to the jury in closing argument. I agree 100% with you that this is an issue of law, and the trial judge should have ruled on it, whether in my favor or against me. And the failure to rule on that issue has led to a significant expense on my client's part because we had to try a case, and now we're here in front of the appellate court.
Did you waive that issue, though, by not objecting to that going into the closing arguments? It seemed like almost trial counsel was recommending the instruction on conspicuous. So did you waive? I guess it's raised in the answer brief. It says that you have waived that argument, being able to argue that in front of us today by not by agreeing that it should go, that issue should go in front of the jury.
Conspicuousness is the second issue I want to talk about, so we'll table my first issue, indemnification, and address this. I do not agree that I've waived anything. I argued conspicuousness at every summary judgment hearing. I argued it at both directed verdicts. The judge denied my motions, denied my arguments in every case. At that point, I'm forced to go to jury. I'm forced to go to closing
argument. So the directed
argument.
verdicts, when you made a motion for directed verdict, you argued that this still should be decided by the court, not the jury. Is that correct? Okay.
I did, Your Honor. And I gave them 3 reasons why: indemnification, conspicuousness, and the failure to have an original agreement to supersede to create an accord and satisfaction.
As you stand here today, then, you agree that the issue of conspicuity should have been determined as a matter of law.
I'm here arguing that the jury trial should have never happened, that the court failed by not ruling either at summary judgment or certainly by directed verdict. I think it's summary judgment, that one, this check did not have anything on it that said indemnification, but at the same time they sent the check, they always send the letter that this court has already ruled on in the Trout v. Apicella case that says, well, we don't really think this changes anything, but we want indemnification. So there's no agreement, there's no meeting of the minds at the very beginning of this case. And you all have said in the Noling versus Manigalu case that indemnification is an essential element requiring assent to form a settlement contract.
I'd like
we
to
don't
go
have
back
that.
to, and thank you for that, counsel. I'd like to go back to conspicuity. Conspicuity, as I understand it, is whether something is conspicuous. I mean, I know that's a big word. And here, is it not undisputed that this lawyer knew exactly what was on this check?
It is disputed, Your Honor, because one, the standard
Disputed
is
that
not,
the lawyer knew that?
it's not a reasonable lawyer standard, Your Honor, it's a reasonable person standard. So
But we know in the record that this lawyer knew what the lawyer read.
this lawyer testified that he was not aware of what the policy limits were, that he thought that this check was contribution or an advance. He testified to that on page 109, and my expert testified to the same thing on page 341 and 348 of the transcript.
Where does it say on the check, advance?
It doesn't say advance, and it doesn't say full and final either. That's the problem, Your Honor. The check is ambiguous, and the check should be construed against the drafter, which is the insurance company. If they wanted this check to be full and final settlement of a policy limits case without disclosing what the policy limits were, then on that check it should have said full and final settlement.
Sometime after he received the check, then he deposits the check, correct? And
The
distributes
instrument
the amounts.
was collected on the 7th of June when it was deposited into the bank.
Then shortly thereafter, he gets some type of correspondence from Geico saying this is a full settlement, correct?
That's 2 months later. On
But
June
within-
11th, he
still
gets-
within the 90-day period under the accord and satisfaction statute, correct?
Correct.
Okay, so
But-
facts, hold on. And so I guess the question is now he knows that Geico is saying this is a full and final settlement. Why not return the money at that point?
First of all, that's long after the money was distributed. The money was distributed a week after the check was deposited to the client because she was in the hospital and needed money to be able to pay her rent so she didn't lose her apartment, okay? The letter that was sent 2 months later that said, this is our settlement, this is our understanding of an agreement, and I'm sure you read in my brief, the adjuster who sent that letter had never had a conversation with anyone. They write this standard letter that says this is our agreement, these are the terms and conditions, but they have no idea when those terms and conditions were agreed to. They can't testify as to anyone ever agreeing to them. So when that letter is sent, the ship has long since sailed in this case. And that portion of the statute that you're talking about, the 90-day portion, does not apply because Section 3 is conditioned on Section 4, and Section 4 requires the other side to prove that Hogan knew in his mind that that was a policy limits tender. And he's testified under oath he didn't know that. He thought it was an advance. So there was no requirement for us to return that, or for Hogan to return that check. I keep saying us because I work there now, but I did not then.
Well, if he was unclear about what it said, which seems to be what you're advancing today, would not the proper course to have been call Geico?
That would be detrimental to the client's interests if this is just an advance, and it could be malpractice.
To call Geico and ask them if this is for full policy limits?
Lo, you've made a mistake. You haven't put full and final on this check. Is it full and final? I mean, you're giving them the out. They've made a mistake. They've made an error. They didn't do their job. They didn't protect their insured by sending a release or at least sending a cover letter or at least writing on the check stub, this is full and final in some conspicuous manner. They didn't write it at all. The only thing conspicuous on that check stub is their ad to save $15 in 15 minutes.
Thank you. I'd like you to explain to me, so you're saying this was strategic, that he believed Geico had made a mistake, and therefore it would have been strategically improper for him to have reached out to Geico by call or letter?
When he researched it, his testimony was that he researched the issue and determined that the check did not meet the requirements to be a full and final settlement. That's what his testimony was. And so he deposited the check and he distributed the funds to the client, and then he filed a lawsuit against the other driver to seek the remaining money that she would be entitled to, because her medical bills are well over $150,000.
Well, I just want to understand, and maybe you misspoke, but you said it would have been improper for him to have reached out at that point in time, and I want to get to the bottom of that.
Because I think that to do so, and he testified to this as well, to reach out to Geico and give them an opportunity to correct what might be an error, what might not be, would be detrimental to his client. If, in fact, he makes that phone call and they go, oh, yeah, we meant it to be full and final, well, now he's limited the client's recovery to $25,000. So that's detrimental to the client. If he does not reach out to Geico, if he waits for them to do their job and protect their insured and they don't do it, he's not adjusting the claim. They are. It's their obligation to make sure that every T is crossed and every I is dotted. They do that with their insureds.
You jumped over a step, though. When he reaches out to Geico and he says, hey, it looks like you may have made a mistake, if they confirm that, then his next step is to not accept the check.
That is one possibility, but
That is the possibility. If they say this is meant to be for full satisfaction and we didn't write it, and you don't want to accept it as full satisfaction, that's your only option, is to not accept the check.
if he reaches out to Geico, I would say that's probably true. But he didn't reach out to Geico, and he had no obligation to reach out to Geico. There's nothing in a statute or a rule or anything that says it's the job of the plaintiff to adjust the claim. And reaching out to Geico to tell them we're not sure what this means is doing exactly that, and that wasn't his job. That's why it's detrimental to his client. Can I talk about indemnification for a moment?
Go ahead.
Thank you. This court has ruled the specific language in that letter that Judge Jay talked about that came 2 months after the check was sent. This court has specifically ruled that letter is not a just, hey, we're just trying to make sure all the I's are dotted. That is a counter offer. And so when they sent this check, they normally send, they've testified to this, they normally send that letter with the check. It's their intent, it's their understanding at that point in time that indemnification is part of cashing that check. And that is not clear on the face of the check.
Well, I mean, you say a counter offer, but you use the term, I like the term. The ship had sailed, but hadn't the ship sailed long before the letter? I mean, if there was an acceptance of this draft, cashed, distributed, according to Geico, according to the underlying defendant appellee on appeal, that's it. That's the end of this.
And if that were the case, then why did the trial court not rule that? Because that wasn't the case.
Well, maybe the court should have.
Maybe they should have. Maybe they would have saved us all a lot of trouble if they had, but they didn't. The court had multiple opportunities to make that ruling, and they didn't make that ruling. And I suspect, I don't know, but I think the reason why is because the judge felt as well that it's not the Hogan and Hogan job to adjust the claim. It's Geico's job to adjust the claim. And Geico didn't do that. Geico exposed their insured to an excess verdict. And now they're just trying to backpedal. This is what they call post-verdict, I can't remember the phrase, but it's post-verdict adjusting. They've created a problem. Now they want to get out of the problem, so now they're going to do some adjusting of the claim. They didn't adjust the claim at the time they should have. If they would have done this correctly, that check would have come, that letter would have come with the check. Hogan would have known at that point that the check is full and final settlement. And then, as Judge McIver mentioned, he could have made a decision as to whether or not we explain to the client this is all there is and we don't think there's going to be any bad faith here, or we're going to reject the check, we're going to file a lawsuit, and we're going to see if we can collect money from the insured himself in order to compensate you for the damages.
I mean, isn't the standard of a reasonable attorney, if he has any question about what this is for, to reach out to Geico, and then that would have solved the problem?
I disagree with that, Your Honor. I think that, first of all, the statute doesn't, again, it's not a reasonable attorney standard. It's a reasonable person standard. But our obligation as plaintiff lawyers is to protect our client's interest at every turn. And to do something that would be detrimental to the client, like call Geico and say, what did you mean by this, I think would be malpractice from my perspective.
Well, you're saying detrimental to the client. Isn't it detrimental to the client to accept something that very well may have been a complete agreement, meaning game over? Isn't that more detrimental to the
No,
client?
because think about it, Your Honor. If in fact that was the case, that's all the money there was. There's no allegation of bad faith in this case. That check was sent within a week or so of the accident, so it's not like, 3 months down the road, 4 months down the road, they're still trying to figure out what to do in a clear liability accident. That's where you come up with bad faith. So there's at the moment that Hogan has this check, he's got to decide if he thinks this is full and final settlement. I know he advised the client there's a possibility that this may be all there is, and that at some point the court may rule against us and decide this is all there is.
Mr. Schacht, you're into your rebuttal time. I'll let you finish answering Judge Jay's question if you wish.
I'm sorry, you broke my train of thought, but I didn't get to talk about my third point either, but I'll talk about that in rebuttal. I'm sorry, I totally lost my train of thought. I apologize, Your Honor. Hogan had an obligation to the client, not to Geico, and he got a check that didn't meet the statutory requirements of what a full and final settlement was, and he advised the client as to what could possibly happen, and the only way that he could possibly get the client more money than that $25,000 was to go ahead and cash that check and disperse it and sue the other person. That was the position he took. And I'd like to reserve the rest of my time for rebuttal, if I could, please.
Thank you.
Thank you, Your Honors.
Good morning. May it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the appellee, the defendant below, Todd Goodwin. Before I get into what I was going to say, I just sort of want to say, I'm sure you can figure out that we disagree with a lot of what my opposing counsel has just said. But as the court knows, this is an appeal of a final judgment that was entered after a jury verdict, where the jury determined that the plaintiff entered into an accord and satisfaction and a binding settlement by accepting, cashing, and failing to return the funds contained in a settlement check that were sent by my client's liability insurer before the lawsuit was filed.
I fully appreciate, we appreciate this case was tried to jury, but try as I might, I don't see a jury issue here. Is it your position that this had to be submitted to this jury?
No, I mean, certainly both parties were moving for summary judgment, and I can say that while I was working on this case, I do, with respect to the accord and satisfaction part of the case, I do see where the trial court was coming from the perspective of there are those lines of cases that talk about, well, the issue of mutual intent may be something that should be tried by the jury. But I think in this case, I totally agree with you. I think this should have been a summary judgment case because I think really there's a lot of different contractual concepts that sort of are at play here. And I think really the contractual part of it, more than the accord and satisfaction part of it, there's no issue. And to me, I think
what Judge Jay would previously ask was dealing with the word, whether this was conspicuous or not. And the statute's very clear that that's for the court to decide.
correct.
So why should this have gone past the summary judgment stage? You're in agreement that it should not have?
I'm agreeing it should not have. I think my client, Mr. Goodwin, there should have been a finding as a matter of law that there was both a settlement and an accord and satisfaction. And when I was talking about the case law, like I said, I think in the common law accord and satisfaction sort of line of cases, I think that's probably, when you read the summary judgment transcript, where the trial court was sort of erring. But I do agree it should have been dealt with as a matter of law.
And I'm familiar in my past life as a trial lawyer with conspicuity questions being questions related to things that maybe non-attorneys are trying to digest, and whether they have proper outlining, or if they're in different colors, or if they're bolded, and I heard that all the time. But here, we know this language was read, so I just don't see how the court could find anything other than it was conspicuous.
Well, I agree with you. I think, first of all, the statute specifically says that's an issue for the court, and that's where to get Judge Boatwright. I do think plaintiffs waive their right to argue that like they do in their brief, because they are the one that they offered a jury instruction asking that the jury be instructed on that. But that...
What do you say? And it was, I think, a reasonable argument on the other side. They moved for summary judgment. It was denied. They moved for a directed verdict. It was denied. And so they felt this should have been resolved as a matter of law, too. But when push came to shove, there was a jury, and the jury had to be instructed. So they did the best they could.
Well, I think that's true, but I think when you look at this limited conspicuous issue, I think that one of the points they raised in their brief is to say, well, the problem here is the judge should have ruled on that as a matter. That's what was waived. I think there's no question both parties were moving for summary judgment and were moving for directed verdict and taking that position. But I think at the end of the day, the important part here is...
Waiver is a big deal. I know you know that. And I, like you, I've tried a lot of cases as a judge and a lawyer. And you do the best you can. And everything is in real time. And you move for directed verdict. The judge denies it. No, the jury's going to decide this. What should have been said to have preserved that after the denial of the motion for directed verdict?
Well, I think during the charge conference, and if you read that Burt Smith case, which is one of the cases plaintiffs cite, that's what the court, it was specifically dealing with the conspicuous statute in the UCC. The court said in that Burt Smith case, yes, the judge was wrong to not address that issue as a matter of law. However, the issue was waived because during the charge conference, nobody objected to it. And here, that's the exact same case, and plaintiff even offered the instruction. But, I mean, I'm not sure that that necessarily matters, because I think at the end of the day, we need to just step back and say, look, whether it was as a matter of law and summary judgment, Mike, there should have been a finding that there was a settlement here and an accord and satisfaction, and the jury came to the right decision. So, you know.
And again, it bothered this judge. You've got lawyers arguing cases to the jury. You've got an expert trying to evaluate statutory text for a jury. I mean, that's surreal to me. I mean, what in the world is going on here? It's like a parallel universe.
Well, but there's no question. And I think, but at the end of the day, really the issue here and why summary judgment or directed verdict, and the jury came to the right conclusion, but the ultimate resolution here really comes down to this, that from a settlement perspective, when you look at this from the concept of acceptance of benefits or this ratification theory, you cannot take the position that you can accept the benefits of a contract and then say, but I'm not entering it into a contract. And that's exactly what was done here.
Why not put on the check? I mean, I guess this is, was raised in the appellant's brief that there should have been some language of full payment or full satisfaction of the claim. I think even under the UCC, under this section, that's in the comments of the UCC under this section, recommends that. Like that's the recommendation. Why not put full payment or full satisfaction of the claim, and then that settles the matter?
Well, it says in settlement of BI claim, and it's very clear what that means. And I think one important thing that I disagree with my opposing counsel on is that when he said that Mr. Hogan testified at trial that he didn't understand what that means. That's absolutely not true, because if you look at, it's at page 106 of the transcript, Mr. Hogan was asked, let me get it. And you fully understood as a practicing lawyer what a settlement of a BI claim means. In this context, yes. So, I mean, the issue here, he understood what it meant. He always did. And that's important from the perspective of the UCC. There's two different ways that you can sort of enforce the UCC. And let me get the statute so I explain it correctly. Okay. there's subsection 2, and that deals with the conspicuous part of it. The claim is discharged if the person against whom the claim is asserted proves that the instrument or accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered. So that's one avenue. And then the second avenue, which is important, is under subsection 4. A claim is discharged if the person against whom the claim is asserted proves that within a reasonable time before the collection of the instrument was initiated, the claimant or an agent of the claimant knew that the instrument was tendered in full satisfaction of the claim. And that's really what this case boils down to, is that they knew. So Mr. Hogan knew, and at the end of the day, the client accepted. The funds were dispersed, and she accepted the money and never gave it back.
In evaluating conspicuity, and I know, as Judge Boatwright pointed out, the statute says this is a judicial function. This is not a jury function. So let's just set that aside for a minute. But in evaluating conspicuity, is it seeing what was written or understanding what was written? It seems to me, understanding that term, it should be seeing it. Or am I misunderstanding what that term means?
No, I think that's absolutely right. And I think that's what the statute talks about it. And it's defined, right, in section 671.201, if a reasonable person would be expected to see it. And the notes to the accord and satisfaction portion of the statute talk about that.
See it versus understanding.
Yes, that if you would expect someone to see it, then it says anything can be conspicuous. And that's where we disagree with my opposing party's position in this case, is that you don't need it to be bold or this. Pretty much the notes say that. If you would expect someone to see it, then almost anything can be conspicuous.
I guess that's my point. We know it was seen.
Correct. And understood. I think that's really,
I think that's ancillary. I mean, based on what you're saying, I think it's just about seeing it on the conspicuity.
Correct. It was seen. I mean, I agree. And again, I think that's why this is sort of the Snickers case, no matter how you slice it. Their position is legally incorrect from a contract sort of concept analysis and from an accord and satisfaction, both statutory and using the common law analysis. I mean, you can't take funds that you know are being offered in settlement of a claim and then say, I'm going to take them, I'm going to keep them, but there's no settlement.
Wouldn't it, following up on Judge Boatwright's question, good question, wouldn't it have been better to put a cover letter with this check or, put a release in this envelope? Wouldn't that have been a better course of conduct here?
Perhaps. I mean, I sort of sound like the counsel in the first case. I mean, when you look retroactive, maybe there's things that could be better. But that's not really.
I'm not sure it's material, but can you satisfy our curiosity? How did that not happen? Is there not a form letter that goes out?
I mean, my understanding, I think that the checks were written and it was just sent out. But again, it says in settlement of BI claim. I mean, if it was just a random check that was sent, then I think we'd be having a different conversation here. But when those words are on there, it doesn't matter if there's a cover letter. I mean, it's very clear in settlement of BI claim. I mean, it's there. Again, Mr. Hogan saw it, he understood what it meant, and the client accepted the money. So again, I don't know that it would change it. And I mean, I guess you could say, I don't know that it would have been different, because even when you look at the statute, it's either looking at the negotiable instrument itself or an accompanying letter. But here, since it's on the actual check, I don't think was necessarily a need for a cover letter. Hopefully my position, I don't want to keep sort of beating a dead horse, or if the court has questions for me, like I said, our position is that at the end of the day, the jury came to the right result. I agree it may have been one that the court probably could have come to much earlier, but the right result was reached here, and there really is no basis for the court to reverse what happened in this case, because at the end of the day, as a matter of law, it was correct to find that there was a settlement and/or an accord and satisfaction was reached.
Thank you. Mr. Schacht, any rebuttal?
interrupt him anyway. Give me one moment, please. May I? Thank you. Really quickly, because I know I have a limited amount of time left, the third issue I had that I wanted to raise was what my expert testified to, and that is simply that the affirmative defense of accord and satisfaction has three elements to it. It's pre-existing dispute, the nature and extent of an obligation, dispute of the nature and extent of an obligation of the parties, mutual intent to settle it by a superseding agreement, and then the execution of the superseding agreement. There was never an original agreement to supersede, and Chobe Ebbets, who testified on our behalf, testified to that. So for that reason, that's one reason that he said that you can't have an accord and satisfaction. The second reason he testified to was the fact that the statute on 4 different areas says that full satisfaction is required to be written on the instrument or on an accompanying writing, and that was not done either. So for both of those reasons.
Isn't that a legal question, though, for the court?
I think I said that when I first got up here. These are legal issues that the trial court failed to address. So we're here because the trial court didn't make the rulings for whatever reason that should have been made in this case. But it's our position that the court should have ruled on behalf of the plaintiff. The statute is clear that full satisfaction is required on the writing, whether it's a contemporaneous writing sent with it, and they testified, their adjuster, that letter sent 2 months later was not contemporaneous. So all you're dealing with is a check that doesn't say anything about indemnification, and it doesn't say the words full and final settlement. And you will find that check, and you'll find the check and the check stub on page 1236 is the check stub. The check itself is on 1235 in the record. It's actually in a bunch of different places in the record.
I've got it.
Perfect. So you can see on there, do you have the stub as well?
Yes, sir.
You can see when you look at that stub, the smallest typeface on that stub is the unbolded terms settlement of BI claim.
But again, back to the question I just asked, if it was not seen, I hear you, but it was seen here, correct?
Yes, and it didn't meet the statutory requirement. It didn't say full satisfaction of bodily injury claim. It just says settlement of bodily injury claim. Partial settlement, full settlement.
But the typeface is irrelevant if it was seen by Mr. Hogan.
I disagree with that. There's a statute that tells you specifically what conspicuousness is, and it spells it out, and it doesn't talk about just, it's specific about a couple of different things, and if you don't mind, I'm going to just tell you. It says conspicuous terms include heading in capital letters equal to or greater in size than the surrounding text. We don't have that. In contrasting type, we don't have that. Font or color, we don't have that. And, not just that, and language in the body of the record or the display in larger type than the surrounding text set off from the surrounding text are the same size symbols or other marks that call attention to the language. They don't meet that requirement, Your Honor.
And I understand that,
Okay.
Counsel. My point is, it was seen here. It was seen by this lawyer here. And the cases I'm familiar with, and I know you know this, I dealt with him for a very long time as a trial lawyer, and you had people that would say, I never read this. I never saw it. I didn't appreciate this. And then conspicuity is a real question, potential. But here it was seen.
It was seen, and he did a legal analysis, and his analysis told him that that did not meet the statutory requirement to effect a full settlement. That was his legal analysis, and that's why the check was deposited, distributed to the client, and suit was filed against the driver of the vehicle to collect the remaining damages that the client was entitled to. You know, to look at that comment in the UCC that says almost anything can be conspicuous, that completely vitiates the statute. The statute is clear what conspicuous it is, and it has to be something that that sets it off. It doesn't matter if you see it or not. It still has these hoops that you have to jump through. Insureds have to jump through hoops all the time in order to be able to keep their policies. They have to pay full price for their policies. If they short the insurance company $10 and they don't pay the late fee, policy's going to be canceled. The insurance company has the same obligations. They have to follow the law. They have to jump through every hoop. And they didn't jump through the hoops in this case. They simply sent a check and then closed their books. And then 2 months later went, oh, geez, maybe we should send a cover letter that says we want indemnification, because that's what we always want anyway, and just to lock down. I think the term they used was, they said, we just wanted to put a bow on the settlement. So, you know, all I can tell you, Your Honor, is that when you look at that check, it doesn't meet the statutory requirements of 673-3111. It doesn't meet 671-201. And it doesn't give you any indication that cashing the check means you've agreed to indemnification. And that's part of their case. They sent a letter saying this check means indemnification. They say we never sent the money back. They never asked for it back. You know,
Mr. Shack, you're over your time. Did you want to just
finish that last thought?
Finish that up, please?
The statute says that they have to prove that Hogan knew. They have to say that he knew that that check was full and final. He knew what settlement of BI means, but it doesn't mean full and final, because it doesn't say it. It means settlement, partial settlement, full settlement, half a settlement. It's not clear. It's ambiguous, and that should be construed against them, and this case should be remanded back to the appellate, or back to the lower court for a ruling consistent with the Monsanto case, which I think you all are familiar with. It's Monsanto v. Edenfield, 426 Southern 2nd, 574. And that case says specifically, conspicuousness is ordinarily made by the trial court, but we decline to remand the case to allow such determination because the trial judge ruling would ultimately be reviewable in this court. So I'm asking you to rule that that check did not have the conspicuous statement that was required, and remand this case with instructions to the trial court to enter a verdict on the affirmative defense in favor of the plaintiff that this check doesn't meet the statute, and allow this case to proceed at trial on the bodily injury claim, on the damages claim itself.
Thank you, Mr. Shack.
Thank you, Your Honors.
Okay. Thank you to both of you. A well-argued case. This concludes our business today, so we will stand in recess.
All rise.